With that having been said, let's get started by talking about the paid sick leave expansion. And what I want to do at the outset, because I think it's helpful, is to talk through what the Healthy Families Act, which is the paid sick leave law here in California, what it currently provides. Because I think if we define what the current parameters are, it'll be easier to digest what's changing as of January 1st. So, number one, under the current law, and this has been in effect since July of 2015, there is a requirement that employees get at least a minimum of 24 hours of paid sick leave each year. Now, that is for all employees, provided that they have worked at least 30 days for your organization. So it doesn't matter whether somebody is classified as exempt. It doesn't matter if they're classified as non-exempt, meaning hourly. It doesn't matter if they're full-time, part-time, or even temporary. As long as they have worked 30 days, they become eligible for this paid sick leave allotment. And as I said, the minimum is 24 hours. Of course, employers can give more than that, but under the current law, there has to be at least 24 hours of paid leave given to employees. Now, under the current law, and this is not changing, there are two methods for providing sick leave. The first method is called the accrual method. Now, the statute says that the default, let's call it, accrual method is that employees accrue 1 hour of sick leave for every 30 hours that they work. And under the current law, they can accrue up to 48 hours of sick leave, but an employer can limit their use of sick leave to only 24 hours in any given 12-month period. So it's important to understand that the accrual method allows employees to carry over unused sick leave into the following 12-month period. I found with my clients under the current sick leave law that most are not using the accrual method. The accrual method creates issues in terms of tracking, and it creates issues in terms of figuring out carryover. But there are some employers that have used the accrual method. And by the way, you can use an alternate accrual method. It does not necessarily have to be 1 hour for every 30 hours of work. But if you use an alternative accrual method, the employee needs to have, a newly hired employee needs to have at least 3 days of sick leave in their bank within 120 days of being hired. So that's the accrual method. As I said, this method is still going to be in effect under the new law, but there's going to be some changes to that. And second, and this is what most employers have done, is called the lump sum method. There's a number of different names people use for it. I often say the bucket method. And what it is that at the start of the 12-month period, whether that's an anniversary date, whether that's a calendar year, the employee just gets the sick leave dumped into their bucket in one lump sum. So there's no accrual. For instance, a lot of employers do it based on calendar year. So on January 1st, 2024, if you're using the lump sum method, you dump in the amount of sick leave that employees are eligible to take over the course of the year, and they can start taking it immediately. The advantage to the lump sum method is, number one, there's no carryover. At the end of the year, any unused sick leave just goes away. It doesn't carry over to the following year. And number two, you don't have to go through the administrative process of tracking the accrual of sick leave. So, as I said, most employers under Healthy Families since 2015 have used the lump sum method. And again, under the new law, both the accrual method and the lump sum method are available for employers to use. So one of the questions or one of the issues that has always arisen under Healthy Families Act is inclusion of the sick leave allotment within PTO. So Healthy Families Act allows employers to roll sick leave into their PTO. In other words, you're not required to grant paid sick leave in one bucket and paid vacation in another bucket. You can combine it all, call it PTO, paid time off, and as long as people get the minimum of 24 hours, you're in compliance with the law. Now, what most employers who use PTO have done is, rather than just give 24 hours, they give whatever vacation allotment their company or organization has decided to use, combine it with the 24 hours, call it PTO, and here you go, employees. Again, there's some advantages and disadvantages to doing that. The advantage is it's simple. It's simple for record keeping. It's simple for tracking. Everybody just gets one bucket, and that's what they get to use over the course of the year. There's some disadvantages, however. The idea of PTO is to give people time off that is paid, and the employer is not supposed to care what that time is used for. If you want to take a mental health day, have at it. Use your PTO. You don't have to pre-schedule it. We ask for some notice in advance if you're taking a planned day. But the idea of PTO is this is your time. You get to take it. So the disadvantage to that is that when you combine Healthy Families paid sick leave with the regular PTO for vacation, it's difficult, if not impossible, to track when someone takes time off, whether that is a Healthy Families sick day or just a regular PTO day. And that's important because under the Healthy Families Act, people have a right to take their paid sick leave. The employer cannot deny employees the use of their paid sick leave. And there's no requirement that the employee provides a doctor's note or some sort of certification showing that it was sick leave taken for a use that is permitted under the law. And so what we run into with combined sick leave vacation into PTO is employers want to control it and say, hey, this employee wants to take PTO and we can't allow them to leave. And then the question is, well, is this a PTO day or is this a Healthy Families paid sick leave day? Because if it's the latter, you can run into liability issues if you deny the employee that time off. The second disadvantage to including sick leave with PTO is that once you call it PTO, it is equivalent to vacation. And so as a result, under California law, you have to pay it out upon termination. So you can't segregate sick leave from vacation in a PTO program. It's all considered vacation and it has to be paid out. And of course, if you put it into two different buckets, with the sick leave portion, you don't have to pay it out upon termination. So the new law allows employers to include sick leave with PTO, but I did want to address those issues because it's something that comes up very often, and it's something that you can change if you're currently on PTO. You can change and split out sick leave and vacation. There's nothing prohibiting you from doing that. And likewise, if you currently have sick leave and vacation in two different buckets, you can move it all into PTO if you choose. It's just a lot easier to do that at the start of whatever 12-month period you're using, whether that's calendar year or anniversary year based on date of hire, or some employers started in July of 2015 when Healthy Families Act became effective, giving it every July. So whatever method you use, that's fine. So the other issue that comes up in the current version of the statute is how do you allot sick leave for newly hired employees? So if you're using the straight accrual method, 1 hour for every 30 hours of worked, they just accrue their sick leave and they get to use it by their 90th day of employment, but there's nothing that says that they have to have a certain amount in their bank by a certain date. However, if you use a different accrual method than 1 hour for every 30 hours worked, or you use the lump sum method, the employee has to have at least the minimum of 24 hours by the 120th day of employment. So you have to make sure that, and this comes up when people are hired late in the year, right? They're hired in August, and you've got a calendar year lump sum sick leave policy. By the 120th day, they have to have the full 24 hours available for use. And then if you want to be consistent with your policy, they're going to get another 24 hours as of January 1. Now, if they don't use those 24 hours before the end of the year, they go away. But a lot of employers make the mistake of saying, well, they were hired in August and we'll wait the 90 days and then they'll just get their sick leave in January. That is not compliant. They need to have 24 hours in their bank available for use by the 120th day. And as we'll see, this is an area that is changing under the new law. So, last thing about the current law, and this is not changing, is the permitted uses for sick leave. The permitted uses are to care for yourself when you have an illness or injury that keeps you out of work, to go to the doctor, either for treatment or for diagnosis, or to care for a family member who is ill. And that includes grandparents, grandchildren, siblings, along with the traditional family members, spouse, children, etc. So those are the permitted uses for sick leave. Employees are not supposed to use sick leave unless it's combined with PTO, right, for just taking a vacation day. However, as I mentioned previously, the law says that employees are not required to submit certification to the employer of their illness or their doctor's appointment justifying their use of paid sick leave. So in reality, in practice, if employees call in and say, I'm sick, I'm taking a sick leave day, you as the employer cannot prohibit them from taking that sick leave day, even if you suspect that maybe they're going skiing. Now, if they're dumb enough to post on Instagram a picture of them at the ski slopes when they took a sick leave day, then there may be some opportunity there to deal with the non-permitted use of sick leave. But absent any true evidence that the employee is taking sick leave for a non-approved use, you really have to allow people to take their sick leave when they say, I need it for my own illness or for a family member illness. So those are the basics of the law as it exists as of today. Let's now talk about what's going to change as of January 1st. So this is the primary thing that probably a lot of you have read about. Effective January 1, the sick leave allotment is going to 40 hours. So 5 days, in essence, of sick leave has to be provided for all employees. Again, this is not just limited to full-time employees. It also covers part-time, even temporary employees. So as of January 1, people get their 5 days of sick leave per year. The accrual carryover rate is increasing to 80 hours. So if you're using the accrual method, as I mentioned previously, there's no change. It's still 1 hour for every 30 hours worked. But at the end of the year, if people have accrued unused sick leave of up to 80 hours, that needs to carry over to the following year. So people can essentially carry over 2 weeks of sick leave. Now, you can still limit their use of sick leave to 40 hours in a year. So if they're carrying over 80 hours, that does not mean they get to take 80 hours, let's say, in 2025. It just means they've got 80 hours in their bank for their use. You, as an employer, can still, limit that to 40 hours of use. So that is a major change to the law. So I want to talk about an issue that's come up a couple times. Excuse me for 1 second. So, speaking of paid sick leave, so that is the issue of how do you calculate the lump sum that you owe employees now that it's switching to 40 hours if you're doing it on a year calendar basis versus an anniversary date. So what I mean by that is if you give everybody sick leave each year, it's very simple. As of January 1, they're going to get their 5 days, and they can use those 5 days throughout the year. But what if you do it on an off cycle? What if you give everybody sick leave each July 1st? Or what if you give employees sick leave on their anniversary date? So here's the question. Do you have to give them the additional 2 days as of January 1st, 2024? Or can you wait until they reach their anniversary date, or July 1st, and then give them their new allotment based on the 40-hour, 5-day requirement? So, of course, this is one of those unknowable questions at this point. I've actually done some research to try to find some guidance on it. There's no guidance in the statute. My belief is that if you're not basing it on the calendar year, the law only requires you to give 40 hours for the 12-month period that you use to track sick leave. So my belief is if you're doing it on anniversary date and you've got an employee who has an anniversary date of March, well, they've got their 3 sick days starting in March 2023 that they've been able to use. And their next 12-month period starts in March of 2024. So, even though the new law takes effect on January 1st, your requirement is to give them 5 days for their 12-month period. So I think you can wait until March and give them 5 days for their next 12-month period. You do not have to give them 2 additional days starting January 1st and then give them their next 5 days starting March 1st. Again, I'm basing that on my reading of the statute and what makes the best, most common sense. There's no guarantee that the Department of Labor Standards Enforcement, which is the California agency that oversees this law, is going to agree with that, and we'll see if that issue comes up in the frequently asked questions that the DLSE is probably going to publish between now and January. But I did want to mention it. It has come up from some of my clients, including maybe some of you on the webinar, and that's my read as of right now. So another change to the law is that you have to accrue your full sick leave allotment for newly hired employees by the 200th day of employment. So if you're using the lump sum method or you're using an alternate accrual method, they have to get their 3 days by 120 days, and they have to get their 5 days by 200 days. So if it's lump sum, they've got to have 5 days available for use by their 200th day, and they have to have 3 days available for use by their 120th day. Most employers are going to just dump it in their bank at the outset of their employment and say you can't use it until you pass 90 days, which is permissible. But just to make sure that everybody understands that that change means that you can't delay giving someone their full 40 hours beyond that 200th day. Here's another thing from a compliance standpoint that you have to think about. Number one, under the Healthy Families Act, you have to show on the pay stub how many hours of sick leave people have remaining for use. So you have to make sure with your payroll company, and don't just assume that they're going to do it on their own, because I've seen too many times where payroll companies say, well, we're not obligated to do that. You have to tell us to do it. Okay? So make sure that your payroll company is adjusting what shows on the pay stubs as of January 1st, for instance. If you're doing lump sum based on calendar year, as of January 1st, their pay stub has to show 40 hours. So that's number one. Make sure your pay stub is updated to reflect that. Number two, every employee is supposed to get a 2810.5 notification. 2810.5 is the labor code section that shows people their hourly rate of pay, their overtime rate of pay, the MPN for workers' comp, and how much sick leave they're entitled to. So make sure that your 2810.5 notices that you're giving to newly hired employees after January 1st reflects the change in how much they're entitled to. And it's probably a good practice to give your current employees something in writing. It can be a memo, it can be a blast email. It doesn't have to use the actual 2810.5 form, but something notifying employees that yes, as of January 1st, they're going to be entitled to this additional sick leave. And again, that's just for compliance purposes, but these are housekeeping things that you've got to pay attention to. And lastly, you got to update your handbook to reflect the new paid sick leave allotment that people are entitled to. One last thing that I want to mention, and that is that this new law states that it preempts certain local paid sick leave laws. So those of you that, for instance, are in the city of Los Angeles or in the city of San Francisco, city of San Diego, Santa Monica, there's a number of different local jurisdictions that have paid sick leave laws. And this is another one of those ambiguities that we don't know the answer to yet. The question is, how much of that local sick leave law is preempted, meaning that it goes away and you get to follow the state? That's going to play out probably over the next couple months. What I would say, if you're in one of those jurisdictions, I would probably continue following what the local law says until you hear otherwise. Because most of what I've read so far indicates that the preemption under the new law is very limited.